When the founder sued his own company, the board called it vanity, until a single email proved they'd been wrong for 6 years. Crestline Industries had built its reputation over 42 years on predictability, steady returns, conservative governance, and a board that operated with the kind of quiet authority that came from never needing to raise its voice. David Winters had been CEO for 11 of those years. He was not the founder. That honor belonged to Jonathan Crestline, who had stepped back from operations in his late 60s but retained chairmanship and a controlling voting bloc through a carefully structured family trust. David had been Jonathan's choice, his protégé, the careful steward of a legacy built on precision and trust. The company's annual meetings were legendary for their brevity. 22 minutes, no drama, no questions that hadn't been vetted in advance. Shareholders received their dividends, executives received their bonuses. The system worked until the letter arrived. It was delivered on a Tuesday morning, hand-couriered to the executive floor. David opened it in his office, standing by the window. Notice of civil action, breach of fiduciary duty and misrepresentation of governance authority. The plaintiff was Jonathan Crestline. David read it twice. Then he set it down on his desk and called the general counsel. Within an hour, the executive committee had convened in the boardroom. "He's challenging the succession agreement," the general counsel said, her voice measured but tight. "He claims the board exceeded its authority when it ratified your appointment. He's arguing that under the original governance charter, certain executive decisions required trust approval, not just board approval." One of the directors leaned forward. "Jonathan signed the succession plan. We all did." "He's not disputing his signature," she replied. "He's disputing the interpretation of what he signed." David sat at the head of the table, his hands folded. He had not spoken yet. "What does he want?" someone asked. The general counsel glanced at David before answering. "Reinstatement of board oversight provisions that were revised in 2019, revalidation of all executive appointments made since then, and a public acknowledgement that the governance structure was altered without proper authority." It was not a demand for money. It was a demand for truth. David finally spoke. "When does this go to court?" 30 days. The room remained still. One of the senior directors, a woman who had been with the company for nearly 20 years, cleared her throat. "What's the likelihood he wins?" The general counsel hesitated. "If the case relies purely on board procedure, we're on solid ground. But if it hinges on charter interpretation and original intent..." She paused. "Jonathan wrote that charter. He knows every clause, every exception, every contingency that was discussed in those early meetings. If there's something we missed, he'll know where to find it." David watched the faces around the table. Some showed concern. Others showed irritation. A few showed the kind of calculation that came from weighing risks against career trajectories. "We need to review everything," David said quietly. "Every amendment, every vote, every communication related to governance changes since 2015. If there's a weakness in our position, I want to know about it before we walk into that courtroom." The meeting adjourned. The directors filed out, already pulling phones from pockets, already composing messages to their own attorneys. David remained in the room alone. He wondered how many people in positions like his had actually read the foundations upon which their authority rested. He wondered if he had. The lawsuit became public 3 days later. Crestline Industries did what it always did when faced with external scrutiny. It issued a statement. Calm, professional, dismissive in the politest possible terms. The board of directors of Crestline Industries has full confidence in its governance procedures and the legitimacy of all executive appointments. We are reviewing the claims raised and will respond through appropriate legal channels. But inside the company, the atmosphere had changed. Jonathan Crestline had not been seen at headquarters in over 2 years. He attended board meetings remotely, voted by proxy, and maintained his chairmanship as a formality, or so everyone had assumed. His filing suggested otherwise. The media coverage was restrained but persistent. Business journals ran profiles of Jonathan's legacy, his careful stewardship, his reputation for ethical precision. They noted his absence from recent governance discussions. They asked questions about the 2019 amendments to the company charter, amendments that had streamlined decision-making and consolidated authority in the executive office. David had supported those amendments. He had drafted some of them himself. In the days that followed, David found himself reviewing those amendments with fresh eyes. He had believed them necessary at the time, a way to modernize the company's decision-making apparatus without sacrificing the integrity Jonathan had built into every system. The board had needed the ability to move faster, to respond to market conditions without waiting for quarterly meetings and layers of approval that seemed designed for a different era. But Jonathan had built those layers for a reason. Each oversight mechanism, each checkpoint, each required approval had served as a safeguard against the kind of incremental authority creep that could transform a board from stewards into owners. David had seen it as inefficiency. Jonathan had seen it as insurance. The first hearing was procedural. Jonathan did not attend. His attorneys did, 2 senior partners from a firm known for governance and fiduciary matters, not aggressive litigation. David sat in the gallery with the general counsel. He watched as Jonathan's lead attorney, a woman named Elena Voss, stood and addressed the judge with the kind of calm authority that came from decades of reading contracts no one else had bothered to finish. Your Honor, this case concerns a single question: whether a board of directors may amend governance authority that was originally vested in a family trust without explicit consent from that trust. The judge looked up. And the company's position? Crestline's attorney stood. That the board acted within its authority as granted by the corporate charter, and that all amendments were properly ratified in accordance with existing procedures. Was the trust notified of these amendments? A pause. The trust's representative, Mr. Crestline, was a sitting board member at the time and participated in the vote. Did he vote in favor? He abstained. The judge made a note. Proceed with discovery. Next hearing in 45 days. It wasn't dramatic. It was not supposed to be. But as David left the courtroom, he felt the weight of something he had not anticipated. Not anger, not betrayal, but the quiet certainty that Jonathan Crestline did not file lawsuits lightly. In the car back to the office, the general counsel sat beside him in silence. Finally, she spoke. He's been planning this for years. David looked at her. What makes you say that? The precision of the filing, the specificity of the claims. He didn't hire attorneys last month and tell them to find something wrong. He knew exactly what he was looking for, which means he's known about this issue since at least 2019. And he's been waiting. Waiting for what? She stared out the window. For the right moment, or maybe for us to prove we couldn't be trusted to fix it ourselves. David said nothing. The car moved through traffic, and he thought about all the decisions he had made with confidence, all the votes he had supported with certainty, all the times he had trusted the advice of counsel without questioning the premises beneath the recommendations. He had been so careful to honor Jonathan's legacy, but he had never stopped to consider whether efficiency and legacy were always compatible. Discovery was meticulous. Jonathan's attorneys requested every governance document produced since 2015, every board resolution, every amendment to the corporate charter, every vote tally, every memo discussing executive authority. Crestline's legal team complied, confident that the record would vindicate the company's position. The amendments had been public. The votes had been recorded. The procedures had been followed. But Elena Voss was not looking for procedural errors. She was looking for definitions. The next hearing was substantive. Jonathan attended. He sat in the front row. He did not look frail. He looked patient. David saw him from across the aisle. Their eyes met briefly. Jonathan nodded once, a gesture so slight it could have been mistaken for a tremor. David did not nod back. Elena Voss stood and addressed the court. "Your Honor, we have reviewed the discovery materials, and we believe the central issue is now clear. In 2002, when Crestline Industries was restructured following its initial public offering, the governance charter explicitly distinguished between two forms of authority: operational and structural." She placed a document on the overhead projector. Operational authority was vested in the board of directors. Structural authority, the power to alter the fundamental governance framework, was reserved for the family trust that held the controlling interest. The judge leaned forward. "And your claim is that the 2019 amendments fell under structural authority?" "Precisely. The amendments redefined the scope of executive decision-making and removed oversight mechanisms that had been in place since the company's founding. That is not an operational adjustment. That is a structural change." Crestline's attorney rose. "Your Honor, the board has consistently exercised authority over governance amendments. This is not a novel interpretation. The trust's role was always understood to be passive." "Passive until it chose not to be," Elena replied. "Mr. Crestline abstained from the 2019 vote because he believed the board lacked the authority to propose such amendments. His abstention was not consent. It was objection." The judge flipped through the documents in front of him. "Was this objection documented?" "Not in the board minutes, but Mr. Crestline did send a private communication to the general counsel at the time, raising concerns about the scope of the proposed changes." She produced the email. It was brief, polite, and devastatingly clear. "I remain uncertain whether the board has authority to redefine structural governance without trust approval. I will abstain from this vote, pending further clarification." The general counsel at the time had responded with reassurances. The vote had proceeded. The amendments had passed. The judge looked at Crestline's attorney. "Did the board seek legal clarification before proceeding?" A hesitation. The board relied on internal legal review, conducted by the general counsel. "Yes." The judge set the email aside. "I'll need to review the original trust documents and the 2002 charter. We'll reconvene in 3 weeks." The courtroom emptied slowly. David remained seated as the gallery cleared. Jonathan was still there, speaking quietly with his attorneys. David stood and walked toward the exit. As he passed Jonathan's row, the older man looked up. "David!" David stopped. Jonathan's voice was calm, almost gentle. "This was never about you." David did not respond. He left the courtroom without looking back. That evening, David sat in his office long after the building had emptied. He thought about the day Jonathan had called him into his office 11 years ago and offered him the CEO position. "You understand precision," Jonathan had said, "and you understand restraint. Those are the things that matter here." David had asked why Jonathan was stepping back. "Because I built something," Jonathan had replied, "and I want to know it will outlast me." David had taken the role seriously. He had studied every structure, every agreement, every tradition that made Crestline what it was. He had respected the legacy, but he had also believed that legacy required evolution. The 2019 amendments had been his proposal, not to seize power, but to streamline it, to remove redundancies that slowed decision-making, to allow the company to respond more quickly to a changing market. The board had agreed. The shareholders had benefited. The results had been undeniable. But Jonathan had abstained. David had assumed the abstention was symbolic, an old man stepping aside to let the next generation lead. He had not considered that it might have been a warning. Now, sitting alone in his office, David pulled up the original 2002 governance charter. He had read it before, but never with the kind of attention Elena Voss had brought to it. The distinction was there, clear as daylight. Operational authority, vested in the board of directors. Structural authority, vested in the controlling trust, as represented by its designated trustee. Jonathan Crestline had been that trustee, and the 2019 amendments had redefined structural governance without his approval. David closed the document. He had been so certain the board had the authority. The General Counsel had confirmed it. The vote had been legitimate. But legitimacy and legality were not always the same thing. And Jonathan Crestline had spent 40 years building a company on the principle that precision mattered, even when it was inconvenient. David opened his email and scrolled back through the archives. He found the thread from March 2019, the internal discussions that had preceded the governance amendments. There were 12 emails. Most were routine: scheduling, document review, vote preparation. But one stood out. It was from Jonathan to the General Counsel, sent 3 days before the vote. The subject line read, "Clarification request." David had never seen it before. It had not been copied to him. It had not been discussed in the board meeting. He opened it. "Margaret, I want to ensure I understand the scope of the proposed amendments correctly. My reading of the 2002 Charter suggests that changes to executive authority structures fall under Section 4.2, which reserves such decisions for trust approval. Your memo indicates the board has sole authority under Section 3.7. These sections appear to be in tension. Before I vote, I would appreciate clarity on which provision governs this particular set of amendments. Best regards, Jonathan." David scrolled down to the response. "Jonathan, after consultation with outside counsel, we are confident that Section 3.7 provides the board with broad authority over governance matters, including the proposed amendments. Section 4.2 was intended to address fundamental ownership structure changes, not operational governance refinements. The vote will proceed as scheduled. Best, Margaret." David read it again. Then he closed his laptop and sat in the darkness. Jonathan had asked the question. The General Counsel had answered. The board had voted. But the question had never truly been resolved, only dismissed. And Jonathan Crestline, patient as ever, had waited 6 years to prove that dismissal was not the same as truth. The final hearing was scheduled for a Thursday morning. David arrived early. He sat in the same seat as before, watching as the room slowly filled. Jonathan entered last, walking with the same unhurried calm he had always carried. He took his seat and folded his hands in his lap. The judge entered. Everyone stood. When they sat again, the judge did not begin with procedural remarks. He simply looked at both legal teams and spoke. "I've reviewed the original trust documents, the 2002 Charter, and the 2019 amendments. I've also reviewed the board minutes and the communication from Mr. Crestline regarding his abstention." He paused. "The question before this court is not whether the board acted in good faith. I believe it did. The question is whether it acted within its authority." He turned to Crestline's attorney. "The charter is unambiguous. Structural authority was reserved for the trust. The 2019 amendments altered the fundamental governance framework of the company. Those amendments required trust approval." Crestline's attorney stood. "Your Honor, with respect, the trust's representative was present at the vote and abstained," the judge interrupted. "An abstention is not consent. It is the absence of consent." The courtroom was silent. The judge continued. "Furthermore, Mr. Crestline explicitly raised concerns about the scope of authority in his communication to the General Counsel. That communication was not addressed substantively. The vote proceeded regardless." He set down his notes. The court finds that the 2019 amendments were adopted without proper authority and are therefore invalid. The governance structure will revert to the framework established in 2002, pending formal ratification through the appropriate channels. David felt the floor shift beneath him, not violently but irrevocably. The judge looked directly at him. This ruling does not invalidate Mr. Winter's position as CEO. His appointment was made under the original governance structure and remains legitimate. However, any executive decisions made under the authority granted by the 2019 amendments will need to be reviewed and, if necessary, re-ratified under the restored framework. He turned to Jonathan. Mr. Crestline, the court recognizes that this lawsuit was not filed to reclaim power, but to restore accountability. That distinction is noted. Jonathan inclined his head slightly but said nothing. The judge stood. This court is adjourned. The press release was brief. Crestline Industries acknowledges the court's ruling and will take all necessary steps to ensure full compliance with its original governance charter. The board of directors reaffirms its commitment to transparency, accountability, and the principles upon which the company was founded. David remained CEO. The board restructured its oversight committees. The trust resumed its formal role in structural governance decisions. There were no resignations, no public apologies, no humiliation. Just a quiet return to the architecture that had been designed to last. The following weeks brought a series of adjustments. Every decision made under the 2019 amendments was reviewed. Most were re-ratified without issue. A few required modification. The process was methodical, deliberate, and strangely therapeutic. A return to the kind of precision that had once defined the company's culture before efficiency became the dominant value. David found himself attending more meetings with Jonathan, not fewer. The trust's restored authority meant that certain strategic decisions now required explicit approval from the man who had built the company. At first, David had expected resistance, second-guessing, or subtle assertions of control. Instead, Jonathan asked questions. Not interrogations, not challenges. Just careful, thoughtful questions that forced David and the board to articulate not just what they wanted to do, but why it mattered and how it aligned with the principles that had made Crestline worth building in the first place. 3 weeks after the ruling, David received a handwritten note. David, precision is not cruelty. It is respect for what was built before us. I never doubted your integrity. I only wanted to ensure the company would survive without mine. David folded the note and placed it in his desk drawer. That evening, he attended a board meeting, the first under the restored governance structure. Jonathan participated remotely, as he always had. When the meeting concluded, David remained on the line after the others had disconnected. "Jonathan," he said quietly. There was a pause. Then Jonathan's voice came through, calm and clear. "Yes? Thank you." Another pause. "You're welcome." The line went silent. David closed his laptop. Somewhere in the city, contracts were being signed, companies were being built, reputations were being earned and lost. And at Crestline Industries, power had quietly returned to the hands it was always meant to rest in, not through force, but through the patient insistence that words meant something. That precision mattered. That legacy was not ownership, it was stewardship, and it endured.